You just kind of motion, wave your hand or something. Oh, yay, oh, yay, oh, yay. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and you shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Good morning. The court has some cases to hand down this morning. Have Civil 19-983, Abraham Grant versus State of Arkansas from Lincoln County Circuit Court. Appeal dismissed, motions moved.
CR 19-748, Zachary Atwood versus State of Arkansas from Faulkner County Circuit Court, affirmed. Justice Wynn concurs. Justice Hart dissents.
CR 19-854, Orlando Dominguez versus State of Arkansas from Howard County Circuit Court, affirmed. Justice Hart dissents.
CR 19-563, Carl Prince versus the State of Arkansas from Sebastian County Circuit Court, Fort Smith District, affirm. Hart dissents.
CV-19-828, Tyrone L. Jones versus Wendy Kelly, Director, Arkansas Department of Corrections from Chico County Circuit Court, affirmed. Justice Hart dissents.
CV-19-982, Walter Sims versus Wendy Kelly, Director of the Arkansas Department of Correction from Lincoln County Circuit Court, affirmed. Justice Hart concurs.
Will the clerk please read the submissions?
There are 11 cases being submitted to the court for decision this morning, the first of which will be orally argued. Civil Case 19-975, Lawrence C. Bandy, MD, and others versus Mildred Vick, an appeal from Pulaski Circuit Court. Also being submitted, Criminal Case 19-643, LaRon Hayes Jr. versus the State of Arkansas from Bradley Circuit. CR 19-745, Matthew Armstrong versus the state from Searcy Circuit. Criminal 19-870, Harold Bennett versus the state from Mississippi Circuit. Criminal 19-981, Curtis Dorsey versus the state from Pulaski Circuit. Criminal 20-60, Jerry McKee versus the state from Green Circuit. Criminal 20-88, Anthony Dwayne Brown versus the state from Ashley Circuit. Criminal 18-495, Jacob Jerome Taylor versus the state from Pulaski Circuit. Criminal 19-421, Robert Woodward versus the state from Chico Circuit. Criminal 19-64, Stephen C. Hayes versus the state from Saline Circuit. And Civil 20-13, Daryl Talley versus Wendy Kelly as the Director of the Department of Correction from Jefferson Circuit. In addition to these 11 cases, also being submitted today are 20 various motions and petitions. All of the submissions, as well as the court's opinions, are available on the court's website.
Okay, thank you, Stacey. Our case for oral argument this morning is Civil 19-975, Bandy versus Vick. And the court will recognize the appellant.
Good morning, Your Honors, and may it please the court. My name is James Estes, and along with co-counsel Scott Provencher, we represent the appellants in this matter, Dr. Lawrence Bandy and his professional association, Arkansas GYN Oncology. Your Honors, this appeal arises from the circuit court's striking of the appellant's demand for a jury trial in this case as a sanction for the party's failure to timely mediate pursuant to the court's scheduling order that was in place. For reversal today, the appellants contend, number one, that the circuit court erred in striking the appellant's fundamental constitutional right to a jury trial. Number two, that the circuit court, when it conducted a trial as a bench trial without a jury, failed to grant a motion for directed verdict or motion for dismissal at the close of the plaintiff's case in chief for the plaintiff failing to satisfy the locality rule in a medical malpractice action. And 3, that the circuit court erred in failing to grant a motion for new trial or JNOV as post-trial motions. Your Honors, in turning to the first point for reversal today, that the circuit court erred in striking the appellant's fundamental right to a jury trial, I'm sure the court is aware of the factual basis that is set out in the briefs, but this was a case of medical malpractice that Mildred Vick had filed in the circuit court of Pulaski County. The circuit court had entered a scheduling order to guide pretrial matters, and as part of that scheduling order, the court did order this case to civil mediation, as the court certainly has the power to do under the Arkansas Dispute Resolution Act. In this case, mediation was not conducted in a timely manner, and certainly before the pretrial hearing, trial counsel for Dr. Bandy and his PA filed a motion to dispense with that order for mediation or to enlarge the time, and readily conceded that the motion should have been brought in a more timely manner, but that the circumstances in this case were that in a case of medical malpractice, Dr. Bandy, under his professional liability policy, had a consent clause, and Dr. Bandy was not going to consent, and certainly counsel felt that everyone submitting to a court-ordered mediation would be a waste of judicial time, money, and expenses. And the circuit court denied the motion to do away with mediation or to enlarge the time, finding that the motion was out of time as well, and basically found that because Mrs. Vick's attorneys had at least inquired about mediation, that the sanction in this case should be to strike the appellant's demand for a jury trial and to keep this matter on the trial docket as scheduled, but as a bench trial. Your Honors, in this case, it's clear that the appellants did have a constitutional right to a jury trial. We know that Article 2, Section 7 of the Arkansas Constitution provides that the right to trial by jury shall remain inviolate. And this court, in recent opinions in the last 3 years, and in the Tilley case, both in 2017 and 19, and in VHC Pinnacle Point versus Nelson, reaffirmed that that right to jury trial is a fundamental constitutional right that's protected by the Constitution of Arkansas, and that procedural rules will not be enacted to diminish that right. The appellee in this case concedes that in this case of medical malpractice, the appellants, both the plaintiff and the defendants in the trial court, were entitled to a jury trial. And in fact, both parties demanded a jury trial. The appellants demanded that upon the filing of the answer. The plaintiffs demanded that upon the filing of their complaint. So once the jury...
Counsel?
Yes, Your Honor.
If I may, you probably heard, be careful what you wish for. Are you at all concerned that the trial court mentioned that perhaps, you know, striking the jury trial was a better option than striking your answer, which the trial court felt was an option?
Your Honor, and
what's your response to that?
Your Honor, our response to that would be that certainly a court has the inherent power to control its docket and to enforce orders. And in this case, we, of course, argue that striking of the jury demand was outside the powers of the court. But if the court were going to consider a sanction, we would argue that certainly striking of an answer would be an abuse of discretion as well, because the violation in failing to timely mediate would certainly not be commensurate with the sanction that the court would want to impose of striking a complete answer. Certainly, the Arkansas Dispute Resolution Act gives the court the power to refer a case for mediation, but there has to be a balancing of encouraging resolution through a dispute resolution process while at the same time maintaining a litigant's absolute right to a trial by jury. So certainly if the court were going to consider another sanction, the appellant's position would be that the sanction should be balanced with what the violation was. And the violation was simply failing to mediate in a timely manner. Certainly at the pretrial, and this was offered in the appellant's motion to enlarge the time, was simply to allow the parties to mediate before the scheduled trial date or to take the matter off the jury trial docket and reset it for a time in the future. And so we believe that the proposed sanction of striking the answer would not be appropriate and would be an abuse of discretion in this case for those reasons, but also because the scheduling order required the parties, all parties, both the plaintiff and the defendant, to complete timely mediation. Yet in this case, the only sanction that was provided by the court by striking the jury demand, or even proposed or considered by the court in striking the answer, was to punish only the appellants. And certainly, as we argued in our brief, the appellees could have also moved to dispense with mediation or moved to compel mediation or move for some relief in accordance with a scheduling order, but did not do so. So we would believe that striking of the answer would be an abuse of discretion as well, because it's not equally applied to both sides when the scheduling order required both parties to mediate. In turning to the central question is, did the court have
Counsel, we've lost your sound.
Your Honors, may I just interject that we did have this issue during our practice run, and I expect for Mr. Estes to reappear here just shortly. The problem seems to be fixed when he signs off and signs back on.
I apologize.
Can you hear me now, Your Honor?
Yes.
Yes.
I apologize for the technical glitch and certainly appreciate the court's understanding. And Justice Wood, in wrapping up my answer previously, also the trial court in this case found that the conduct by either the appellants or the appellees was not deliberate and not willful. So certainly we would believe that the extreme remedy of striking an answer would be an abuse of discretion if that were actually considered and enacted by the trial court. But in turning to the question of whether the court had the power to take away the jury demand, in recent case law, we understand that the jury demand and whether a jury demand can be waived is found in Arkansas Rules of Civil Procedure 38 and 39. Rule 38 provides that once a jury demand, not a request, but a demand for a fundamental right is made, that it can only be withdrawn with consent of the parties. Rule 39 then defines what that consent process is. Rule 39 says that once a demand is made under Rule 38, that those issues shall be tried by a jury unless one of two things happen. That the parties, either by written stipulation filed with the court, consent to a trial on the trial by the bench without a jury, or number two, in open court, make an oral stipulation on the record that they consent to trial without a jury. And in this case, neither one of those.
Counselor,
Yes.
if we agree with you, if we agree that your right to a jury trial was improperly taken from you, then what is the proper disposition here?
Your Honor, I believe that if the court reaches that threshold issue that we were deprived of a right to trial by jury, then the case should be remanded for a jury trial in this case. The appellees argue that basically the court had the power to do this because of the Arkansas dispute resolution statute. However, in that statute, there is no express language that gives the trial court the ability to remove a constitutional right of a trial by jury. In fact, the only thing that statute it gives the court the power to order a case to mediation, and it gives the court discretionary authority to enforce the results of a mediation, but it does not give the court the power to remove a constitutional fundamental right to jury trial as a sanction for failing to abide in a timely manner by the court's order for mediation.
Counsel,
So, yes, Your Honor.
why is your remedy not a reverse and dismiss under your point 2 on appeal that the court erred in not granting you your motion for a directed verdict?
Your Honor, certainly we argued that in the alternative, that if the court had the power to sit without a jury, that the court did in fact err, because it's clear from the record that the proof that was submitted by the appellee in a case of medical malpractice included no foundational requirement of proving the locality rule. So we do argue that the trial court erred in that determination. And
well, I guess I'm confused why that wouldn't be your primary argument. Are you saying you'd rather go try it again than just outright win your case?
No, certainly, Your Honors, we would take the dismissal if the courts found that, but under the constitutional argument that we've made, that if the court does find that a constitutional right was deprived and does remand it for trial, we believe it should be remanded without a jury. If the court does agree with the second point on appeal that was argued in the alternative, then certainly the remedy would be a dismissal with prejudice for the failure of proof on behalf of the plaintiffs in a medical malpractice action.
Mr. Estes, let me just make sure I understand what you just said, that if we reversed and remanded without a jury trial, is that what you just said?
No, Your Honor, if I did, I misspoke. I said certainly if this court remands to the trial court, it should be a trial by jury as demanded, as that was never withdrawn. However, we do believe that the court does have the power to dismiss this with prejudice under the second prong of our argument. If the court were to conclude that our second argument had merit, that what was presented at the trial, which was conducted improperly because there was no jury, that the plaintiffs failed to meet their burden of proof under the locality rule.
So if this court agreed with your point number 1 argument, in your opinion, would it be necessary for us to get to your other arguments?
Your Honor, I don't believe it would be necessary. And that I certainly understand the question of would we rather a trial by jury or certainly a dismissal outright. And of course, the answer is a dismissal outright. But the primary argument in the case, in which was...
Counselor, that's not how you answered me when I asked. I asked. And you responded, reverse and remand, trial by jury.
Your Honor, that is the relief requested primarily in argument 1.
And that's the second you just gave me.
I'm sorry, I can't hear you, Your Honor.
And that was the answer you gave me when I asked initially that if we agreed with you, what would the proper disposition be? And you said reverse and remand, trial by jury.
Correct, Your Honor.
And now it sounds like you're vacillating.
Well, no, Your Honor. In all due respect, I'm simply saying that in our second argument, if the court were to accept our second argument, that the trial that was conducted, what we argue improperly without a jury, if they accept the results of that the plaintiff failed to meet their burden of proof, then the remedy would be a dismissal with prejudice. Your Honors, I see that I'm into my rebuttal time. Yes,
I do have one question before you go, and that concerns on your first point, the demand for jury trial. What is our standard of review there? Because we have said in Tilly that our review is de novo on the right to a jury trial, but a bench trial we review for clear error, and we had a bench trial here. So what standard of review should apply?
Your Honor, I believe the standard of review would be de novo because it is the stripping of a constitutional fundamental right I believe the court has said that in evaluating fundamental rights, that it would be a de novo review to see if the court committed an error of law, which would be de novo.
Thank you.
Thank you, Your Honors. I'll say,
Mr. Estes, before you sit down, I have a couple other questions. I'm concerned about the fact that your client would not consent to the mediation, although ordered by the circuit judge. And the second part of that is, I understand the circuit judge found that the action of the attorneys was not deliberate or willful. But the action of your client obviously was deliberate and willful. How would you account for that with the circuit judge? And if the circuit judge did decide that your actions based on your client was deliberate and willful, do you think the sanction was proper?
Your Honor, I appreciate the question. And certainly in a case of medical malpractice, consent is typically an issue in the insurance clause that an insurance company cannot settle or pay money under the insurance policy without the consent of the policyholder. And as was raised in the motion to dispense with mediation or enlarged time, Dr. Bandy had not consented, and certainly that was his right under his policy. Certainly the legislature has enacted the Dispute Resolution Act to encourage settlement, but it certainly cannot demand that a litigant consent under a malpractice policy, which if it's consented for and paid under that policy, requires reporting to the National Practitioner Data Bank, to the State Medical Board, various professional concerns. Certainly the court, by ordering mediation, cannot order a litigant to consent to settle. Certainly the process can encourage it, but simply withholding consent, even if the consent was withheld at a mediation, would not be improper, deliberate, willful violation of a court's order. And that's what was raised in the motion to enlarge time or motion to do away with the mediation, is that Dr. Bandy had not consented and that counsel did not expect that would change. So therefore, we do not believe that Dr. Bandy's actions would be considered willful or deliberate. And I think that the trial court, when you read the trial court's comments in the abstract from the hearing, understood that consent is an issue in these types of cases. So I don't believe the trial court would find the client's actions willful or deliberate, and certainly wouldn't be deserving of the sanction of removing constitutional fundamental right to jury trial.
Thank you.
Any other questions before I pass? Thank you, Your Honor.
Okay, the court will acknowledge the appellee.
Thank you, Chief Justice. Good morning, and may it please the court. Brian Wallace on behalf of the appellee, Mildred Vick, who is the plaintiff below. Justice Wynn, I would like to first address the question that you just posed to my opposing counsel about the refusal to mediate by Dr. Bandy and whether that sanction was proper. And we contend that it was a proper sanction in this case based upon the court's ability to enforce its order. And that is important here because we're not just dealing with the court saying, you know, you failed to follow a procedural rule, so I'm going to take this away. This is where the court issued a scheduling order. And he listed all the deadlines, the discovery deadline, the motions deadline, the mediation deadline. And specific to that, he put a little asterisk that said this is ordered pursuant to Arkansas Code annotated 16-7202. Notification by correspondence to the court of compliance with the mediation deadline is required. And then he goes further. He advises that failure to comply with any of the pretrial requirements, not just this mediation order, but the discovery, motions, any of them, may result in removal from the jury trial docket, dismissal of claims, striking of affirmative defenses, or the prohibition of the introduction of certain testimony and or exhibits.
Counselor, doesn't that seem extreme? a circuit judge could make a list of things that you can and cannot do, and then cherry pick which constitutional rights that he is willing to take away if you violate those.
Well, Justice Hudson, the court wasn't cherry picking what constitutional rights to take away. He was advising the parties pursuant to the authority granted by the statute 167202 dealing with mediation, that he was authorized to enforce orders of mediation, as well as the
statute would give him the right to take away a right to a jury trial if you mess up his scheduling order, his timing.
This isn't about messing up the scheduling order or the timing. This is about failing to comply with an order. The statute provides a means to dispense with an order to mediate if there's good cause. And that's what we have here. The parties knew in May of 2019, months before the discovery deadline, that Dr. Bandy was refusing to mediate. And plaintiff reached out, as the court noted in his discussion of this, and tried to mediate. You know, we can advise the court that mediation would be a waste of time if that's Dr. Bandy's position. Please address this with the court. Dr. Bandy responded, we can wait to address this with the court. When the motions deadline came up, which was after the mediation deadline, it was brought up again. Should we file something? And that's when Dr. Bandy moved to dispense with mediation, after the fact. So right here, there's notice as to what the process is to dispense with the mediation order, and therefore to avoid the penalties that have been listed. And this was a lesser penalty here. This was a lesser sanction. As has already been recognized, the court said that the other option was to strike the answer and just have a trial on damages. And with that, we need to keep in mind that this wasn't the first part of the court's order that the parties had violated. And I will say that there was a sanction to both parties. Ms. Vick just accepted the jury trial sanction and agreed to try it to the bench. But the first time that they violated the order, which the court noted prior to issuing its ruling and sanction here, that the parties also failed to comply with the discovery order. So he had that knowledge when making this discretionary decision, which that goes to the standard of review, Justice Baker, that you brought up. We do have a de novo standard of review. However, in enforcing orders to mediate, the statute advises that the court has discretionary authority to enforce the orders related to mediation. So I would say in this instance, there is a little bit of an overlap in the standard of review here.
Counsel, and we've discussed, and you just mentioned about the trial court mentioned striking the answer, but from what I can find, I can't find anything in our rules that allow a circuit judge to strike an answer in a situation like this either. So we have the ability to strike an answer for Rule 11 sanctions, for failure to respond to discovery, but I don't find a rule that allows striking an answer for this. Do you? So there potentially isn't a worse sanction.
Justice Wood, I believe, but I do not have it in front of me, but I believe that Rule 37 does provide for the striking of an answer.
That's for discovery, and this wasn't a discovery failure.
That is for failure to comply with the court's discovery order, which I would say is analogous to the situation that we have here, which is failure to comply with the court's order. Other than that, I can't think of one offhand except for the statute itself, which allows the court to enforce the order here. I would like to address Justice Hudson's question. If we agree the right to the jury trial was improperly taken, then what is the remedy? I would say that the sanction would be imposed by this court would have to be the court's alternative, because in discussing his analysis and his reasoning behind the sanction, he said that his alternative was to strike the answer and just to have a trial on damages. So if the court were to disagree with our position, which we respectfully request that it doesn't, as we believe the law stands on our side and the facts of this case support the court's decision here. But we would say that the alternative would be that you have to have the answer stricken and that there would be a jury trial on damages only. That would be the alternative sanction here based upon what is in the record.
But counsel, again, can you cite me to a rule that says an answer can be stricken for failure to comply with mediation?
Your Honor, I don't believe it needs to be just a rule. We have the statute. We have 16702 that says the court is granted the discretionary order to make at the request of a party appropriate orders to confirm and enforce the results produced. That is a broad discretional authority to enforce its orders. The court has long been granted the authority to run its courtroom in the manner in which it wishes. Which brings me to.
But counsel, what's exactly the point of the ordering the mediation if you get to the point of you have this doctor that says, I am not going to settle. I want my day in court. I want my jury trial. What is the point of requiring the resources being spent on mediation if you have a defendant that says, I want my day in court, I want my constitutional jury trial? Why allow a circuit judge to force them to go through that process?
Your Honor, because the General Assembly has established that it's the public policy to favor mediation and has authorized the courts to order the parties to mediation. And because of that, what the court did here was proper. And there is an ability to opt out by filing the timely motion. If the motion had been timely, we wouldn't have this issue. The motion wasn't timely. And I'd like to address the question of whether this is a taking away of the constitutional right to a jury trial. That is not absolute. It can be waived in a manner prescribed by law, and also.
And are you excuse me, counsel, are you contending that not complying with the mediation order in this case was the equivalent of a waiver?
I am saying, Your Honor, that refusing to comply with a court's order, which included directions that the court be advised prior to the mediation deadline of the results, and that the parties follow the statute and move pursuant to the statute to dismiss for good cause, I would say that in this instance, the court can enforce the order in the manner in which it has done because it told the parties ahead of time this is what it was going to do.
You are arguing that it's a waiver.
I am arguing that it's a waiver, yes, Your Honor. I thought I said yes at the beginning of my speech.
And just to be clear, counsel, you're arguing that the General Assembly has the right to pass a statute that would allow for a jury trial request to be nullified.
No, Your Honor. I'm arguing that the General Assembly has passed the statute, and the constitutionality of the statute or the authority to do so was not challenged below. So that question is not before the court, and I'm just simply saying that both parties have conceded in this case the court's authority was pursuant to the statute, and the court could order the parties to mediation.
But your argument seems to rest on the power that the General Assembly would have to enact a statute that would authorize the withdrawal involuntarily of a jury trial request.
It rests on the court following the statutes that are currently in place and acting as it felt was appropriate under the law as it stands right now.
Counselor, dovetailing into what Justice Womack just asked, wouldn't that be quite the slippery slope if this case, this opinion that you're suggesting that we would write in your favor would allow for the General Assembly to create statutes which essentially allow a circuit judge to whittle away at a constitutional right? How can the General Assembly write a statute to trump the Constitution?
Your Honor, with all due respect, this case is a fact-specific situation where those arguments weren't raised. So I don't believe that this opens the door, creates a slippery slope, as this is a factual specific situation to the order that was entered by the circuit court, advising what will happen, the parties failing to do it, and the court issuing a sanction in conjunction therewith. Whatever happens with the statute after this case, that's beyond what is going on today, and I don't believe that it would be appropriate to go into that in the court's opinion. I think it can be limited to this specific circumstance and what occurred in this case.
So, counsel, you're saying that the legislature has provided the manner prescribed by law by which the jury trial right can be waived, and they've done it by the passage of the statute.
Yes, Your Honor. And we're also saying that
But they have not done that, but they haven't done it explicitly. The statute doesn't explicitly provide for the waiver of jury trial in this manner. Correct?
Yes, Justice Baker. It does not explicitly provide it. Instead, it provides the court broad discretional authority to do what it deems fit to enforce its mediation order, just as under the common law, courts have been given broad authority to enforce and to run their courtrooms as they see fit. And that, Your Honor, would be one of the ways in which we say that this was a manner prescribed by law, as it is not limited to the procedural rules. Tilley and the other case law has made clear that a manner prescribed by law encompasses all manner of the law in the state. Your Honor, I would like, if there are no further questions on the right to the jury trial issue, I'd like to briefly address the locality rule and the sufficiency argument that was kind of briefly brought up at the end on why, if we had, why wouldn't that be the remedy, just dismiss if that's not enough? Respectfully, it would not be appropriate because there was no abuse of discretion here. The evidence was appropriately let in. There was sufficient evidence before the directed verdict that Dr. Bandy breached the standard of care in the locality. It was specifically said. Dr. Griffin spoke about his experience. He spoke about knowing what Dr. Bandy had his fellowship in. And that factual information went in. And all of that is in the record. But what I want to point out and highlight within the record is that all the deposition, all the testimony, the expert testimony went in by a deposition. The depositions were designated ahead of time, the parties exchanged. And so everyone knew that this locality rule evidence existed. And it was just a mistake that it didn't get put in. And it wasn't an abuse of discretion for the court to put that in this bench trial, as there was no prejudice here. And if the case were remanded on the jury trial issue, this evidence exists. We know it's there. We knew it was appropriate to deny the directed verdict on the first go around. And so we know this evidence will be back there as well. So that's the part that I would like to address on there. Otherwise, I believe that the briefing and the record fully covers that locality rule issue, unless there are some specific questions for me from the court on that. Well, Justices, if I see that I do not have any more questions, we submit that the case should be affirmed. The circuit court here acted within its authority to enforce its order to mediate. The parties were advised ahead of time what would happen if you did not comply with that order to mediate, and what would comply if you didn't comply with the discovery deadline or the motions deadline. All of those matters contained in the scheduling order. So because of that, we would ask that the court affirm, and if there are no further questions, I will rest for the day. Thank you.
Court recognized rebuttal for the appellate.
Thank you, Your Honor, and I'm not sure how much time I have remaining because I think I went into my rebuttal time previously, but
A little less than 7 minutes.
okay. Thank you, Your Honor. In response, I would like to address the appellee's argument that the court has the ability to enforce its scheduling order, and I'm certainly not disputing that a court has the ability to interpret and enforce orders that it makes, but a trial court does not have the authority to enforce an order that deprives a litigant of a constitutional right. And in this case, the scheduling order that was entered basically says that failure to comply with any of the pretrial requirements may result in removal from the jury trial docket, dismissal of claims, striking of affirmative defenses, or prohibition of the introduction of certain testimony and or exhibits. So when a constitutional right to jury trial, which this court has said and recently reaffirmed is a fundamental right, there has to be due process notice to advise a litigant, even if the court had the power to do it, which we argue that the court didn't, to advise a litigant that you're going to lose your constitutional right if you fail to do something. And clearly, this order does not do that. So while a circuit court has the ability to enforce its orders and to interpret its own orders, it does not have a right.
Mr. Estes, we've lost your audio again.
Again, I apologize. Technology is not on our side this morning, so certainly I'm not sure why we're losing our audio, but we're having to redial in when that happens, so I apologize.
Okay, we've got you back. You've got 5 minutes and 24 seconds left.
Thank you, Your Honors. Part of the argument that was made in our brief is that even if the court had this power, which we do not believe constitutionally that the court did, that the notice that was provided in the scheduling order does not say that a litigant will lose their right to a jury trial. It says it simply would be removed from the jury docket. And in this case, that would, in talking about an appropriate sanction for failing to mediate.
Counsel, isn't it well known that whether you're on the jury docket or the bench docket, you know what that means in circuit court. It's well established. So you were on notice that if it's removed from jury docket, you didn't know what that meant?
And Your Honor, respectfully, I believe a reasonable interpretation of that would be that it would be removed from the docket as the current trial setting and would simply be continued until the parties could mediate. Matter of fact, earlier in the hearing, the court, I believe it's early in the abstract, had indicated he had just dealt with 2 other cases which had been previously continued a year ago under same or similar circumstances. So certainly it wouldn't be a reasonable interpretation that you would lose your right to jury trial when Rule 39 indicates along with 38, that once a demand is made for the constitutional right of a jury trial, it shall be docketed on the jury trial, and that it can only be removed, forfeited, waived, if the parties consent. And they have to consent in writing that's filed with a court or orally on the record to consent to trial without a jury. So if that is the constitutional provision as interpreted by this court, who has the ability to write the rules in accordance with the Constitution, it would not be a reasonable interpretation to believe that that notice provided in the scheduling order would mean that a circuit court then has the ability to remove a constitutional right in a manner that is not prescribed by the Supreme Court in Rule 38 and 39.
Counsel, how do you respond to their request that this court should reverse in order the answer be struck?
Your Honor, I do not believe there's any precedent for this court to, if this court finds that truly a constitutional right has been deprived, Dr. Bandy and his professional association, then I do not believe this court then has the ability to determine what sanction, if any, would be appropriate in the alternative. The court in the hearing indicated that he was considering different sanctions, one of which would be striking of the answer. And again, Justice Wood, in following up on a question that you raised with the appellee, I do not believe that, earlier I indicated I believe it would be an abuse of discretion to do that. But again, there is no rule. Rule 37 wouldn't apply because this is not a discovery issue. This is not a Rule 11 issue. And striking of an answer was not even listed in the court scheduling order as a potential sanction. The court indicated it would strike affirmative defenses.
Counsel, would that be a question of fact for the trial court if the trial court determine what sanction, if any?
Yes, Your Honor. I believe that if this court did find that the jury trial was improperly stricken and remanded, then I guess the court in its discretion could take up what sanction would be appropriate if the sanction that it has previously entered was found to be improper by this court. But we do not believe that this court has the authority to enter a sanction for failure to abide by a court's scheduling order, and that would be a decision to be made by the trial court that the trial court should make after careful consideration and not abuse its discretion in making that decision if this case is remanded. Your Honors, it is clear that the appellants had a fundamental right to jury trial, and as a right that is subject to protection, this court has recognized the only ways in which it can be waived or forfeited. And in this case, the trial court did abuse its discretion and abuse its inherent power by striking the jury demand when the court had no power to do that. The alternative argument that we have raised is if the court does conclude that the court had the power to remove the jury demand, that the evidence that was presented was not sufficient. And this court has made it clear in Plymate and Williamson and Schaefer, Schaefer was a Court of Appeals opinion, that the evidence must be presented before the plaintiff rests to satisfy the locality rule, and that an expert has to testify as to what the standard of care is in the locality where the care was provided, and has to testify that they're familiar with either that standard or standard in a similar community. That evidence was not provided, and therefore the defendants were entitled to a directed verdict if that court had the power to listen to the case without a jury. Your Honor, for all the reasons that we've argued and for all the reasons in our briefs, we believe that this court should reverse the trial court's order, and we pray that the court does that. Thank you, Your Honors.
Okay, thank you, counselors. That concludes our oral argument today. And court